right? That's a choice.
We voted on it.
So you're not.
But no, excuse me, hey, please. Special exception, if you listen to our attorney, has been decided by the Pennsylvania Supreme Court is neither an exception or special. It is, if it's listed in the ordinance. There are additional criteria in a zone that allows other things by right. The applicant meets those requirements, we can establish some additional conditions to be placed on it. We have done that.
What are they?
Those of you, Bill, do you want to list those conditions?
So you just voted on them, do you understand them?
Yes.
Oh, can you explain them to me, please?
No. I am done. The hearing has been concluded.
That's fine, we understand, we just would like some explanation, that's all. That's why we're all here.
I understand that, but again, the situation is we are following what the law says.
But if it were given, why would you have to vote on it? That's what I can't wrap my head around.
Because the law stipulates that when you do a zoning ordinance, you have by right, which means you can do it. You have special exceptions, which, as I said, are neither special nor exception, but there are additional criteria that are placed in that zone for whatever it is. That comes in front of the zoning hearing board. You can also have conditional uses. Conditional uses are very similar to special exceptions, except they go back to the governing body. Under the law, if it's a special exception or a conditional use, it has to go back to one of those two entities for a vote. Again, if the applicant meets the requirements of the ordinance and the conditions that are spelled out in the ordinance, the Supreme Court of Pennsylvania said it's basically a by right stipulation.
But if you have to vote on it, you could have voted no, right?
Not if it meets the conditions. If the applicant would have come in and did not meet those conditions, you're correct.
So
we could have.
So the conditions that this applicant met?
Which is Verizon, is that what you're saying?
Correct, the applicant is Verizon.
But they're not meeting their conditions at the Landisville Elementary School where the readings are 4 times higher than what was.
Yeah, they're not following their own guidelines, and you're trusting.
The readings there are, it still does not come back to the township and or the zoning hearing board. The federal government sets the requirements. If you have proof that the readings are higher, you can go and have,
okay.
But that's not this board. The board took the facts that for this at Rorastown, their engineers say they will be within the requirements of the federal limit, the FCC's federal, which is a federal agency's limitations.
Well, of course they say they will be, but we already have proof that they're not.
Excuse me.
I'm going to turn it over to Bill. Bill?
Yes.
I have a question for Mr. Coswell, if I may. Ma'am, it's a cordial and amiable question.
It really doesn't matter whether it's cordial or impolite, but what everybody needs to understand is that the board held 2 hearings on this matter. The hearings were concluded in June. The evidence was presented. I mean, the law sets forth the procedure. It's very similar to a court proceeding. After the parties rest, parties can't come back in and try to present new evidence for the court or a jury to hear. This board acts in zoning matters in effect both as the jury to find the facts as presented and as the judge to interpret the applicable law in this case. It may help, although I understand your feelings, and if I read this, you obviously still may have disagreement, but maybe it will help, particularly for those of you who did not become parties and therefore won't be receiving a copy of the decision. Just, if I may quickly read the discussion part of the decision that the board's acted upon tonight, and it's partly what Chairman Herr has been trying to explain. And what the discussion part of the decision states is that the board has limited jurisdiction and the board recognizes that limited jurisdiction. And what's before the board in this case is what's known as a special exception. And that term has frequently been recognized by the courts and also experts in the field of Pennsylvania zoning law and practice is what's often characterized as a misnomer. So you hear special before exception, and the immediate reaction is this is some sort of permission that's out of the ordinary. But it really isn't. It's a listing within the zoning ordinance, and there are probably special exception uses in every zoning district in East Hempfield Township. And in this particular zoning district, there's a special exception that the supervisors, when they enacted the ordinance, authorized for telecommunication towers in the district where the elementary school, the Varsity Elementary School, is located. So once the elected officials of the township have designated as a special exception use a telecommunications facility, the function of this board is to determine whether the specific standards that are contained in the zoning ordinance for telecommunication towers have been met. And the applicant at the two hearings went through each of the criteria for this particular special exception, and the board concluded that the applicant had met those criteria. Once the applicant meets those criteria, the burden of proof shifts to those who object to the application to show by a high degree of probability that the use would be adverse to the health, safety, and welfare of the community. So you might say, okay, well, it seems obvious that to have a cell tower next to an elementary school raises questions that many of the objectors in this case raise. But then, as you'll see in the discussion, for those of you who received the written decision, the decision goes on to explain that not only is this board limited in terms of its decision-making by the law of Pennsylvania relating to special exceptions, but this board also cannot override, nor can the township supervisors override federal law that deals with standards for telecommunications facilities. And the Telecommunications Act has set forth standards concerning electromagnetic transmissions and radiation, and those same standards are in the Code of Federal Regulations and indicate that unless the emissions are over a certain limit and they comply with the FCC regulations, local government, whether it be the supervisors or this board, has no jurisdiction. It's a matter of, I'm sure many of you are versed in the Constitution, and the federal law is generally supreme and preempts and overrides state and local law. So if the federal government has established standards for radio frequency emissions, this board can't on its own say, well, we don't care what the federal government has done, we're going to set our own standards and determine that we're not bound by those standards, and the board simply can't do that. And you'll see in the discussion part of the decision that I think this is true, having talked to each member of this board who are volunteers and they're not elected officials, and they put a lot of time in not only on this case but on all the cases that come before them. And the discussion part of the decision says the board does not take lightly the concerns raised in these proceedings by the objectors, the people who are opposed to this request. However, the board must follow the law and may not exceed its jurisdiction. The school district, as the landowner, has entered into a lease with the applicant, Verizon Wireless, for the placement or construction of the proposed cellular facilities with the knowledge that there is an elementary school in the vicinity. The township has zoned the property, that be the board of supervisors, the elected officials, to allow telecommunications antennas and towers by special exception. The Federal Communications Commission has limited the ability of local government to regulate the installation of wireless service facilities on the basis of the environmental effects of radio frequency emissions. It is within this legal framework that the board must render a decision in this case. And there were also, and I understand the passion with which this case is approached by many of the residents, particularly those who have children who attend the elementary school. But as I said, it was made clear, and it's just the law, and if you think about it, it's really a matter of fundamental fairness in any judicial proceeding, that parties can't, after the hearing's over, submit hearsay evidence and things that weren't presented at the hearing, and then, because the other side isn't there to respond or rebut these kind of statements. So after the June hearing and when the record was closed, the board had to base its decision, on what was before it at that point in time. And technically, even internet articles about fire hazards and radio frequency emissions are really hearsay. There's no opportunity for the other party, the applicant, to address these internet articles. 3 parties who objected did submit materials within the deadline. I believe it was July 5th. The applicant submitted, its proposed findings of fact and conclusions of law within that deadline. After that time, additional information kept flowing in, which the board simply is not permitted, to take notice of. Again, fundamental fairness in any kind of judicial proceeding or quasi-judicial proceeding like this is. So you really got to understand that this board is in many ways under the same constraints that judges are under. They can't be getting letters from parties and saying, we want to argue our case further even though the trial's over. So this board had to go with what was presented at the hearings, and had to go with the submissions by the parties that were allowed to be made up until July 5th.